the law would require that you find the defendant not guilty. That's because you've not heard any evidence in this case, and the defendant is presumed innocent. That won't change, or hasn't changed, simply because the attorneys have told you what they believe the evidence in the case will show. Now, someone may ask you whether or not you think the defendant has done something wrong, or else you wouldn't be here. However, that's an improper question. We don't just randomly select people from the street to suddenly appear in a courtroom as a defendant in a case. Obviously, there is a process in place which resulted in the filing of charges against the defendant. However, the charges against the defendant are not evidence either. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed any crime. As such, the defendant is presumed to be innocent, and until the district attorney presents sufficient evidence to overcome that presumption beyond a reasonable doubt, you must continue to presume the defendant is innocent. Stated differently, unless and until the prosecution presents sufficient evidence to overcome the presumption of innocence beyond a reasonable doubt, Ms. Stauchs' guilt has not been proven. That's what the presumption of innocence means. You may find it helpful to think of the charges in this case as similar to a recipe from a cookbook. When we get to the end, there'll be charges, and each one of those charges has certain elements. And the prosecution must prove each one of those elements beyond a reasonable doubt. Now, for instance, suppose for a moment that you wanted to have a Denver omelet, and you took some eggs and you scrambled them up. You added some ham, you added some mushrooms, you added some cheese. In that event, you might have a really nice ham and cheese omelet, but you wouldn't have a Denver omelet. If the prosecution charges the defendant with a Denver omelet, the prosecution has to prove a Denver omelet. No substitutions on the menu are allowed. Proving ham and cheese omelet isn't enough. They have to prove beyond a reasonable doubt what they have charged and not something else. I also want to talk about the defendant's right to remain silent for a moment. Someone may ask you whether or not you think you would need to hear from both sides in order to be fair. Everyone wants to be fair, right? And you can only do that if you hear both sides, right? But that's an improper question, because that's not the process that we follow in a court of law. This isn't the Maury Povich or Jerry Springer show. The government brought these charges against an individual. Because of that, the government has the burden of proving the charges beyond a reasonable doubt. The defendant has no obligation to disprove the government's case. The defendant does not have to present any evidence or any testimony. In addition, every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. That's because it isn't evidence. It does not prove anything and must not be considered for any purpose. Sometimes you will hear attorneys ask jurors questions that are intended to elicit a response from you, such as, well, I know if I were accused of something, I would make sure that I took the stand and told my side of the story. That's probably a pretty natural response from everybody. I get that a lot from jurors. As I indicated earlier, that's kind of a trick question, because that's not the process we follow in a court proceeding. In any event, does anyone know what the number one psychological fear in the population is? It's higher than a fear of dying, and most people find it even scarier than meeting up with a rattlesnake. Yep, public speaking. So, of course, what we do is we bring you all down here and have you speak in front of everybody else, and sometimes get asked about some very private matters in your life in front of a bunch of complete strangers. All of you have been subjected to questioning by myself. Soon you'll be subjected to questioning by the attorneys, and I want you to think on that experience. Were you nervous? Were you uncomfortable? If you had a choice, would you choose not to be questioned? The bottom line is that it is possible that the defendant won't testify, and it's possible that the defendant will testify. But regardless of who testifies and who doesn't, the question is always the same. And that is, based on the evidence that has been presented, whatever that evidence is, has the prosecution proven beyond a reasonable doubt that the defendant is guilty of the crime charged? Is there anyone who thinks that they would have to hear from the defendant before deciding the issues in this case? Please raise your hand. No response. Is there anyone who thinks that they cannot give the defendant the presumption of innocence to which she is entitled in this case? Please raise your hand. Okay. Juror number 5. Tell me about that.
I think all murders should be death penalty cases. I think the insanity defense should not exist.
Okay.
I could go on.
No, I understand your feeling, and do you need some water back there? Are you doing okay? Okay. All right. If there's anything that we can do, throat lozenges, anything like that? No, it's okay. I just want to see if there's anything that we can do to help you. Okay. All right. No, I understand that, and I understand your feelings. And juror number 6, you had your hand raised. Tell me about that.
I just made up my mind.
Okay. Anyone else in the back row? Juror number 7?
Made up my mind too, and I just don't think I'll be able to change it.
Okay. Juror number 8?
I feel like I made my mind. Leave it. Insanity.
Okay. I'm glad you did that because I almost missed it. Juror number 10? Okay. And in the front row? Oh, no, I already got that. Actually, juror number 1. Okay, missed. Tell me about that. Juror number 1? Okay. In the front row, juror number 13.
I don't know how I got lucky enough to be 13, but my problem is, if you kill somebody, you kill somebody. Whether you're insane while you do it, you still killed them. The insanity thing is...
Okay. Let me see if this helps, okay? Because it's a really complex area of the law. And somebody else had mentioned the death penalty. And Colorado does not have the death penalty anymore. It did for a while, and I actually presided over a death penalty case. And even when the law recognized the death penalty, you could have a first-degree murder, but constitutionally, not every first-degree murder was eligible for the death penalty. At the time that Colorado had a death penalty, there were 17 aggravators that could be considered to determine whether or not the death penalty should be imposed. One of which was killing a number of people in a number of different episodes. Another one was doing it in a reckless fashion. So that's why it was applied in the Aurora Theater shooting. So because you had a number of murders there, you also had it done in a reckless manner. It wasn't targeted in any specific person. So that's what that was about. One of the issues about murder and sanity, if you are selected to serve as a juror, you will receive an instruction that is worded by lawyers. I just don't know how else to say it. And it says every physical act must be accompanied by a culpable mental state. And that's actually the language that it uses. And the reason for that is people can do things and certain actions happen, but you're not always held responsible for that unless some other mental state was going on. Oftentimes, the easiest thing to deal with are tickets because that just requires a certain act. You're going 65 in a 50. We don't care whether you meant to do it. We don't care whether you knew you were doing it. Those sorts of things. The sheer act of doing 65 in a 50 is enough. In other cases, criminal law is designed to modify behavior. And if you don't know that you're doing something, or you have a condition that is occurring such that you don't understand exactly what's going on, and I've had cases where insanity was pled before as well. I had one where a person beat their mother to death with a guitar. And I won't go into the long facts of that, but ultimately the law takes the position that it is not proper to hold somebody responsible for an act that maybe they didn't know that they were doing or that they didn't intend to do under the circumstances. Does that sort of make sense?
I guess yes, but
Okay, and then I'll get to the insanity part, which is a little bit different, because the insanity part is that there was, and I have the instructions, and if you're selected to serve as a juror, you'll get those, but the insanity part is intended to have the jury closely examine the mental state of the person at the time the crime was committed, because each act has to be accompanied by a culpable mental state. And the prosecution has the burden of proving both of those beyond a reasonable doubt. Does that make sense so far? Okay. So in an insanity plea, what the jury focuses on is the culpable mental state issue and whether or not there was that mental state that is associated with that crime. It could be, in Colorado, there's a number of different ones. There's intentional, there's knowingly, there's reckless, and that's pretty much it. So, but all of those have different, very specific definitions. And so the question is, was something going on such that they couldn't form a particular mental state? Does that make sense?
it does. The problem I have with it is at the time of the crime, this was this mental state. They're being evaluated after the fact. How do we know what that mental state is at the time that somebody's getting killed?
And that part I get, and that part is for the experts. And you would also get an instruction if you're selected to serve as a juror. You'll get an instruction about what an expert is and those sorts of things. But ultimately, the last sentence of that instruction reads, "You may believe all, part, or none of the testimony of an expert." So you can listen to what they have to say. You can say, this makes sense. In the Aurora Theater shooting, it did. In other cases, in the case that I had where the young man killed his mother, it did. And I actually was the one that made the decision in that case. That case was tried to me. So whether you believe something or not is an entirely different question. And I'm not asking that. And there's nobody that's going to ask you that, because that's improper. That's invading the juror's province. What you choose to believe is up to you. The question is whether or not, simply because it's an insanity defense, you're going to say, just not going to happen, don't care what the law is, not going to follow it, I just don't believe in it. And that's my question for you. Do you, or could you look at this and say, well, I don't know what the evidence is going to show. It might not. I don't know. Where are you on that scale?
I don't know.
Okay.
I mean, you don't know what you don't know, right? I haven't been
Right.
presented with evidence.
No, and that's fair, and that's all I'm asking for is an honest answer. And sometimes the honest answer is, I don't know. And it sounds like maybe you have to wait until you get there, it sounds like. But at this point, you don't know. That's fair. Right. Anyone else in this? Okay. Juror 15?
Yeah, to be honest with you, I'm not really sure on if I'd be able to actually do that, and it's coming from a personal place. And having had some experiences as a child as well, and culturally, I think it would be really difficult for me to be unbiased in my responses and how I would internalize that mentally.
You said something there, and I'm not trying to be insensitive, and I certainly don't want it to come across that way. But you said culturally, and I didn't give me some context.
I was raised in the West Indies on one of the islands, and what happens is, and I can speak because I was raised there, and most of my family's from there. I do see that a lot of child abuse does happen, and it's natural. It's like normalized. Okay, so
Okay.
I mean,
Widely accepted.
Yeah, it's
Okay.
generally accepted.
Okay.
To put you in your place, and that's the
Got it.
understanding.
Okay. All right.
Right? So, like, personally, I've been hit with pots in my head. I've been beat with brooms. I mean, I've been hit with hangers, and this is normal. Okay, so I would really have a difficult time processing that and really coming to a place where I would be unbiased, and that's just the honest truth.
Okay. No, thanks for giving me some context. I understand it a little bit better. Juror 16, did you have your hand up? Yes, sir.
Being a father of an 11-year-old boy, I don't think I can be unbiased in this situation.
Jurors, did you have juror 17? Yes.
I have a question.
Yes.
Talk to us about presuming innocence, right? But when I hear, by reason of insanity, what I hear is really she's guilty. You have to decide whether or not her mental state excuses that.
You know, you have probably saved a lot of people 3 years of law school. Because to an extent that kind of is accurate. It is, go ahead, come on.